Medical negligence occurs when a medical practitioner is negligent in treating a patient or when he fails to take proper action on a patient's medical condition. Recent studies and research on complications suffered by patients in our hospital has focused attention on the harsh reality that the legal system in Queensland is geared against plaintiffs pursuing negligence claims against doctors and hospitals. The sad fact is the medical negligence compensation system in Australia, and Queensland specifically, is geared against patient claims. If a claim is brought against a doctor or hospital, that is when a complex and expensive process begins for the victim. A report by the Grattan Institute showed studies that 1 in every 9 patients who go to hospital in Australia end up suffering a complication, about 900,000 patients each year. In light of the research by the Grattan Institute, it has been very hard to prove negligence, except in extreme cases. This seems to be due to the court's reluctance to find doctors' negligence for mistakes, unless they are morbidly apparent mistakes. The scope of this presentation is to critically assess and examine the current issues of medical negligence laws in Queensland and discuss whether or not it appropriately balances the needs of injured plaintiffs. First, this presentation will briefly break down the elements of negligence and how it applies to medical professionals. I will specifically cover the issues of breach of duty, the Bolam test, how it interacts with the professional standards defence under the Civil Liability Act, and whether the issues of breach of duty and standard of care sufficiently favours both doctors and patients. Overall, this presentation will look at the effects of statutory limits and current reform legislations and what they have on medical claims. Consequently, various case law and the IPP report will be referred to support the view of unbalanced needs of injured patients. Breach of duty is a major principle of negligence, which mainly questions if the defendant was careless by not meeting the required minimum standard of care applicable to him. The case of Varipatis v. Almario is an example where general practitioners are only negligent when they do not take one of the precautions that is consistent with reasonable care. Dr. Varipatis was essentially excused by the fact that his patient had a history of being unable or unwilling to follow advice, and because obesity was not understood as a cause of liver disease. This case is really a wake-up call for medical practitioners to respond more aggressively and with a clear strategy to patients who presently appear severely obese. This also raises the question as to what constitutes as careless when exercising reasonable care and skill in respect of examination, diagnosis, and treatment of the patient, as well as the provision of information. The case of Morocco v. Marshman is another example of where immunity is given to negligent doctors. In this case, the negligent failure to warn was covered due to the availability of a causation defence. One of the concerns which instigated the review of the law of torts were the level of standard of care required by a doctor. There are 2 main approaches to determining whether a doctor had breached his or her duty of care, and thus was negligent. Section 21 is concerned with the duty of a doctor to warn of risk. In this regard, the Act provides that a doctor does not breach a duty to take precaution against a risk of harm unless the doctor gives the patient the following information about the risk. The IPP report recommended a comprise of the 2 positions. As a result of that, recommendation of the law has been set out clearly in Sections 22 of the Civil Liability Act. The reform is generally regarded as tending to reduce the liability of doctors. You can see from the clauses in Section 22 of the Act, the Bolam principle is contained in subsection 1. However, the Act allows Queensland courts not to accept the Bolam principle if the court considers that the opinion is irrational or contrary to a written law. It has been held that by consideration of the language in the sections, this is a defence and not an integer of breach, and so must be specifically pleaded by the defendant. Causation is a complex legal principle that is an essential component in establishing negligence, where it has been described by critics as esoteric and poorly defined. It is therefore unsurprising that there is no universal definition that the courts have accepted. At common law, judges adopted the but-for test to aid in satisfying the causation requirements. The causation element can be problematic in failure to warn cases, a specific niche with medical negligence involving a failure of a medical practitioner to warn a patient of a material risk is associated with a procedure or medication. Establishing causation can be difficult where there is a need for the plaintiff to establish a worse outcome because of the negligent treatment. Therefore, it can be viewed that causation in medical negligence litigation is inherently complex and can genuinely prevent a plaintiff succeeding where they are faced with causation argument from the defendant. The current system in Australia for handling claims of injury alleged to be consequence of medical treatment is fault-based and generally requires the pursuit of damages in the courts on the ground of negligence. When a negligence action has been successfully proved by a plaintiff, the court awards compensatory damages. The assessment of damages were governed by common law principles, with the court exercising its discretion in determining the quantum of the damages. As a result of the tort law reform, there are now statutory limits placed on the recovery of damages, including the use of thresholds and caps. The purpose of statutory limits is to limit the amount and extent of liability and to thereby make it less attractive for plaintiffs to commence proceedings. The publication and enforcement of the IPP report in 2002 was intended to stabilise indemnity costs, but the tort system remains slow, where cases can take years to settle, can be costly, inefficient, stressful and often inequitable, and an unpredictable means of assisting people harmed through medical care. Apart from the obvious stresses to litigants occasioned by the costs, delays and uncertainties, there are further structural problems in the existing system. For claims under the head of non-economic loss, plaintiffs must now reach a threshold before an amount will be awarded under this head of damages. Included in non-economic loss is pain and suffering, loss of amenities of life, loss of enjoyment of life, and in some jurisdictions, disfigurement. Per the IPP report recommendations, Queensland has adopted a different approach to the other states and do not have a threshold but has a sliding scale. After the release of the IPP report in 2002, there was substantially a vast limit in the amount of award in damages. Recommendations were made for the cap of $250,000 on damages for non-economic loss. Queensland adopted this cap, but in 2010 made further amendments. The IPP report also recommended that loss of earning capacity to be capped to twice the average weekly earnings. In all jurisdictions, there are caps for the loss of earning capacity, which restricts the amount that may be awarded. Exemplary damages is usually awarded in circumstances where the defendant displayed some conscious wrongdoing, demonstrating that the rights of the plaintiff have been disregarded by the defendant for the purpose of deterring certain behaviour. In response to a recommendation in the IPP report, Queensland have abolished the awarding of exemplary damages with some exceptions. No-fault schemes rectify many faults of tort law compensation. The scheme is timely and provides consistent amount of damages for similar cases, and it also allows the injured plaintiff to get the funds they need within weeks to months. It is arguable that no-fault schemes provide more effective compensation for personal injury than tort law, especially considering the restricted operation of tort law after the 2002 reforms. However, the undercompensation of victims in no-fault schemes is a seriously concerning problem. This demonstrates that no-fault schemes and common law negligence alone are not the satisfactory method for compensation of personal injury, but rather an alternative scheme should be considered. The idea of an alternative scheme would be to avoid many disadvantages of both tort and no-fault systems in their ability to compensate for personal injury. The scheme could potentially be funded by damages paid by the defendants, as well as being supplemented by taxation. The state would be financially capable of compensating more generously than pure no-fault schemes. Clearly, such alternative offers practical benefits and a more satisfactory approach to compensation than either tort or no-fault schemes. In my view, a pattern can be seen to emerge from current tort law reforms, the civil liability legislation and statutory limits, where it is clearly intended to limit the circumstances in which claims can be made and liability imposed, and also to limit the amount of compensation that is payable. This result is understandable considering the objectives of the IPP report, which were to restate the law of negligence. This is clear proof that medical negligence laws do not appropriately balance the needs of injured patients and society in general. It is not only because of the successful use of defences, but also rather the use of statutory limits, thresholds and caps, which limit the assessment of damages. The proposed reforms mentioned earlier could resolve the shortcomings of the common law more effectively. They may also enhance the standard of medical care in Australia in the long run.